Graham Young has written a really important piece in the Spectator magazine this week about the Love case. This is an important case in the High Court. It's not about love, unfortunately. Its full legal name is the Love and Toms versus the Commonwealth 2020 case. It involves two men of Aboriginal descent named Love and Toms. One of them was born in Papua New Guinea and the other one in New Zealand. Now, while of Aboriginal descent, they were not Australian citizens, but they lived here for almost all of their lives and they had permanent residency visas. Mr. Love had been sentenced to 12 months in jail for assault and Toms to 18 months for domestic violence. Now, as they weren't Australian citizens, the federal government proposed to deport them back to PNG and New Zealand in line with their criminal deportation policy. Graham Young writes that these cases have always felt mean to him. Love and Toms are technically in breach of the immigration law and the state has the right to deport them. But to what end? It's not the human rights issue here that Graham's concerned about. It's the precedent that this ruling sets in our law and what it might mean for the rights of people of Aboriginal descent versus the rest of us. The ruling by the High Court, handed down in February 2020, says that Aboriginal Australians could not be classified as aliens even if they're not technically citizens. They always have the right to stay here under Section 51 of the Australian Constitution. Sounds fair enough, especially in this particular case. But what happens when this principle gets applied to other things in other cases? How will it be interpreted in future cases around Aboriginal sovereignty or Aboriginality? Similar to The Voice, it seems to have created a two-tiered system of fundamental citizenship rights based on a person's ethnic origin or race. And that is a very big precedent to set. And it can't be taken lightly, no matter how just it might seem in this one particular case. Graham has given me permission to share his article with you, so here's what he says. The case means that now, if you're an Aboriginal, you can never be an alien because of your unique relationship to the land and its unique relationship to you. It's a relationship that gazumps citizenship. While the government can make laws about who is or isn't a citizen, they can't decide who is or isn't an alien. As Aborigines can never be aliens, they can never be deported, irrespective of whether they're citizens. Now, the problems with this are actually big, and they bear on the voice to Parliament in a number of ways. Now, the High Court might argue that it's not a religious or legal claim of ownership, but something akin to biology, like a native plant or a native animal. But how disgusting and dehumanising a justification that would be. Or maybe it's a claim based on tenure. But what's the bar for tenure? Not all Aborigines arrived at the same time, and some Europeans have ancestries going back over 250 years themselves. Is it possible for the descendants of first fleeters to ever be aliens? Yet while the High Court majority gave a very concrete ruling in this case about who could or could not be an alien, they reached their desired ends very differently. Rule of law means, among other things, that the law should be consistent, and it's a primary role of judges using precedents, statutes and logic to be as consistent as possible. When they fail, so does the rule of law, and it becomes merely the rule of lawyers. What will the court decide when faced with a new chapter in the Constitution giving new rights to Aborigines, as the Voice to Parliament constitutional chapter will? We can't know. But what we do know is that in this case, they have given Aborigines rights that no other person has or can ever achieve. And this status goes beyond the rights of citizenship. And this is why Graham says he is concerned with a constitutionally entrenched voice to Parliament. And I am too, as are many others. While the government keeps telling us we should already know what the Voice is all about and scolding us for not knowing, shut up and vote yes, you racist, this is just bullying us. This thing, at this point, has unknown and unknowable scope to make recommendations about matters affecting Aboriginal people, which ultimately affect all Australians. The interpretation of the proposed Voice amendment to the Constitution will be at the mercy of the High Court, the majority of which we now know, thanks to the Love case, hold a mystical view of Aboriginality, affirming the idea that Aborigines are in some way owned by the land and therefore have a higher status than citizenship and the rest of us. These are alarming concepts from a Liberal Democratic point of view, which inject elements into our legal system that are religious, anti-human rights, anti-democratic, and authoritarian. And when taken to their logical conclusion, they actually demean Aboriginal people. If you enjoyed that content, there's lots more where that came from. The Other Side Australia is back every Tuesday and Friday on ADH TV and all good podcast platforms. It's your weekly short circuit summary of the best news commentary from Australia and abroad. Don't miss it.